and the like. So I'm preparing the live stream. Hold on, YouTube takes forever. I don't know why.
Listen, I can't do all this, whatever you're doing. I have no idea.
All right, let
Once
me
you say,
pin you.
okay.
I'm gonna pin you and get out of here.
Hello, hello. Thank you for joining us. I am Sharon Hoskins of Hoskins Life and Legacy Planning PC, and I am here today to talk to you about estate planning and why it is so important for you to do estate planning so that you can protect the wealth that you are building during your lifetime. I know we had a lot of speakers talking about building generational wealth and giving you tips on the financial side of things. Well, I want to talk about how to protect all of that financial status that you have gained from what you may have learned today. I'm going to share my screen and we'll get started. All right. So we have about 30 minutes, and usually when I give these talks, I usually spend about an hour or more because there's just so much to share with you. But we're going to jump in and go through it today. And let me just, I just want to see if I can try one thing here. It's not letting me. All right. So today I want to talk to you about 4 key things that you should not do, right? You see on the screen, 4 things that you should not do. And I like to have a little fun and use some divas that you may recognize. And if you listen to them a little bit, then you can follow their advice, quote unquote, and do as I am advising here. And you'll see what I mean as we go forward. And so, Destiny's Child, no, 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 no. Don't lose control. Don't ever give anything to anyone you love. Don't own anything. And don't put your kid's name on the deed to your house. Right now, you might be saying, what are you talking about? This woman is crazy. Well, you'll see what I mean as we go forward. So, first of all, Janet Jackson, my girl Janet, I want to be the one in control. You remember that song? Control of what I say, control of what I do. Well, if you do estate planning and you have the essential components of an effective estate plan, you will be in control. So when we talk about being in control and having those key components of an estate plan, we're talking about a power of attorney. We're talking about your healthcare proxy, the living will and personal care plan, a living trust, a last will and testament, and a disposition of remains. Now, let's go into the power of attorney first, right? When we talk about staying in control, you want to know that either when you're alive and well, you're in control, obviously. But what if something happens to you and you can't speak for yourself? You want to know that you've given authority to someone you trust and who knows what your wishes are to be in control of your finances, your legal matters, and even your health decisions. So, with a power of attorney, that's appointing someone to be in charge of your legal and financial matters. The power of attorney is only good while you are still alive. Once you pass, it's no, it's null and void. It's not valid anymore. So with the power of attorney, you can give a lot of leeway in terms of what they can do, but you can also limit it to certain things. So you can have even more than one power of attorney and give different authorities, different areas of control to different people if you wanted to do that. There's some flexibility in what you can do, but it is important to have one because if something happens to you, say you're in a hospital and you're there for a while, and you need someone to just even take care of paying your bills, doing things for you, and you want to make sure it's someone you trust. Now, with the healthcare proxy, that is going to be someone who's going to take care of your medical decisions. When you can't speak for yourself, perhaps you're undergoing surgery or perhaps it's some more serious illness, then the doctors are going to look to the next of kin if they don't have this healthcare proxy in place for you. But if you do have it, they're going to go to your agent and they're going to look for you, to that healthcare proxy agent to give them guidance on what to do. So it really comes in to play when you might be seriously ill and possibly dying. And you will have made decisions as to what you would be okay with doctors doing. Some people say, do not resuscitate. I don't want anything to be done. Let everything happen naturally. Others are like, hook me up to every machine you have, give me every needle, every IV, and try to keep me here alive on earth as long as possible. It's important for your healthcare proxy to know what your wishes are so they can be guided accordingly and make sure your wishes are being carried out. And with that healthcare proxy comes along a living will. The living will is the instruction that you leave for your healthcare proxy agent so that they know what you're doing. So those go hand in hand. And what we do here at Hoskins Life and Legacy Planning with our plans, we go a little bit further with that. We have a personal care plan. And in that personal care plan, it states those wishes that a living will would have, but it also goes into instructions that a caregiver could use for you, right? So we're talking about, what do you like to eat? What do you like to watch on TV? What hobbies might you have? Because maybe you're physically able to do things. And so if you like, doing puzzles, you like knitting, you can still have an opportunity to do that. If you like to read books or listen to audiobooks. So the personal care plan is your detailed instruction book about you, your dislikes and likes, and what things your caregiver can do to make you most comfortable and enjoy the life that you have at that moment. And then finally, the disposition of remains is the document that says who is going to be in control of your body after you have passed on. Because it goes to, if there's no one named, it goes to the next of kin. And that can be a little sketchy sometimes. They had a situation in one of our clients where the man died. He had been married, but wasn't sure whether they were legally divorced. He was living with his girlfriend for like 10 years. And then he had his mother who was still alive. Now, here's the thing. The mother was Christian. The decedent was Muslim, and so was the girlfriend. And the wife was also Muslim. So this guy probably wanted a Muslim burial, but because the next of kin in that situation would go to the wife, it could happen, but the mother didn't want her to do that. And the girlfriend's like, hey, what about me? Well, it turned out that they actually were divorced, so she was no longer the next of kin. But the girlfriend, the longtime living girlfriend, had no say. It went to the mother, who gave him a Christian burial, which is not what he actually wanted. He wanted a Muslim burial, and no one was really very happy. So had he done what he could have done by making a plan, that could have been arranged ahead of time and avoided that scenario. But things happen. So there are downsides to not letting your plans be known in a legal way that can be enforced. And so what if you don't have any of those documents? Right? I already talked about the disposition of remains. What about the power of attorney and the healthcare proxy? If you don't have that, what happens to you? Well, if you can't take care of yourself, somebody's got to do it. And so your family member, or it could be someone else or an agency, will have to go to court and get guardianship over you, legal guardianship over your finances and even over your person. And it doesn't necessarily have to be a family member. The judge can appoint anyone, and there is a list of attorneys and others who volunteer, or not volunteer, who are assigned to the list, who will take assignments to be the guardian of someone else. And that you have to go through a trial and a hearing. It can get expensive, and it may not have the outcome that a family member may want. Like, Wendy Williams is a perfect example. Her family has no control over what's going on with her now. She has a guardian assigned by the court, and the family is not happy with what's going on. So it's very important that we take the time to put these plans in place so that you are in control of what happens to you and assign people to take care of those tasks for you. Now, next topic, don't ever give anything to anyone you love. Now, you're like, what are you talking about? that's the whole point of a will, right? We want to give things to our loved ones and say where our assets go. Well, the key word here is give, right? And we'll get into that. The question now is, do I need a will or a trust? This or that, right? That choice is yours, but I'm going to tell you things that you consider and what the difference is. First of all, with a will equals probate and that equals court, right? So probate is the court process, the legal process by which you implement the will of a person who has passed. And it's very similar to this. It's the same process if the person died without a will. It's still going to court and the court is in control. Now, your will may say, I want, my sister to have this, my brother to have that, my children to get these items. But the person who you appointed your executor, the one who is going to carry those things out, can't even get to work on doing that until the court gives the okay. And I should have mentioned earlier, I am in New York, so I am basing all of my information on New York law. There may be some slight differences if you're not in New York, but generally the provisions are the same in most other states. So in New York, however, the probate process is extremely long, and it can take 3, 4, 6 months even for the executor to be approved, even longer in some cases. And then once the executor is approved, they still can't start giving out the assets. They're required to keep that estate open for 7 months before they can give things away, just in case there are creditors out there that want to stake their claim and say, hey, they owe me this, they didn't pay that. They have to wait and handle all of that before it can be done. So you're really talking about a year or more before things can get settled. And so you'll see down here on the slide, it's time consuming. There are fees involved. So it does, as compared to a trust, a will may be less expensive to draft. But on the other end, when someone passes away, the family is paying more fees to distribute the assets because you're paying for that application to go into the court. And it's often a percentage of the value of the estate. So just for, let's make numbers real easy, if it's $1 million estate, then the most firms are charging anywhere from about 3 to 7% of the estate. So midway, let's say 5%. It can cost about $50,000 to probate that $1 million estate because it's a percentage of the assets. So it can get expensive on the back end. So that's family members are going to have to pay that or take it out of the share that they were to receive in order to completely probate that will. And then I already mentioned the delays. It is a public process. It gets filed with the court, so anyone can go in and look it up and see what was left to anyone, see who all the beneficiaries are, and more importantly, see what the assets are. And lots of times there'll be real estate agents who send people down to the court to look and see if there's any real property that might be coming up, possibly for sale because someone passed away and it needs to be sold. We get calls about that after we file probate petitions, so it's quite common. And it also makes it easy when it's a will. It's easy for someone to contest because at least in the New York process, all the immediate family members have to be notified and they have to sign a waiver. And if they don't sign that waiver, then the executor can't move forward. So essentially it's contesting the will. And then if they decide that they do want to actually file something to say, hey, I think I should be getting a piece of this or more than what I was given, now you've got litigation on your hands. So there's a lot going on with the will process. It's still better to have a will than to not, but there are some of these things behind the scenes that people really don't know about and don't consider. So that's a will. Now, what about a trust? The trust is, the document where you can say, I want my sister to get this, my brother to get that, my children to get these items. And here's the thing, you don't have to go through probate. You don't have to go to court. The trustee, who is the person that's going to be managing the trust assets for you after you die, they just simply distribute it according to the rules that are set forth in the trust that you created. So there's no waiting and holding things open for the court to approve or anything like that. You just set up the trust. Now, what does it mean when I say we set up a trust? So there are two types of trust, right? There's a testamentary trust. This is the type of trust that actually is only created through a will. So you could have a will that says, I want to leave this house in trust for my children. But that type of trust, it doesn't get set up until you already pass away. And so that's one way of using a trust. The living trust is the one that gives more flexibility. The living trust, there's the revocable trust and an irrevocable trust. Now, as a living trust, right, if you're setting one up, you can be the grantor, meaning you're the one who puts the assets or funds into the trust. You can be the trustee, which is the person who manages the trust assets. And then there's a beneficiary. And the beneficiary is the one who can benefit from it, who receives the assets in the trust. Now, with a revocable trust, right, and I like to call that the open box trust. If you look on the slide, if you're seeing that, that says RLT, Revocable Living Trust, open box, because you can put things in and you can take it out pretty easy. You can also be the grantor, the trustee, and the beneficiary. So you can be all three roles. You take your assets, you put it in the revocable living trust in that open box. And for some reason, if you want to take it out of the trust, you can with no problem. Here's the thing. That trust, like I said, will avoid probate. But it doesn't give you asset protection, because if you can get into that open box, then that means your creditors can also get at that too. If you want asset protection, then you're looking at the irrevocable closed box. That's the one in the middle, IRR-AP. That AP is asset protection. In that case, you can be the grantor, you can still be a trustee, and you may also would want to have a co-trustee, but you cannot be the beneficiary. Somebody else is going to be the beneficiary. And since it is a closed box trust, you put things in, you can't take them out. But you see that little faucet that's kind of there, a little drip, that indicates that you can take out the income. So if you have investment accounts that are in your closed box as a protection trust, and it earns, there are gains on it, you can take out the gain, right, the income, and use it for yourself. But the underlying assets, the stocks, the mutual funds that you might have in that investment account have to remain there for your named beneficiaries. Here's the thing, though. You can always change your beneficiary at any time. You can change the allocation. You can change who your trustee is. So there's some flexibility. It's not as rigid as it might sound. And then finally, that third box that says IRR tax. That's a different type of trust. In that trust, you may be the grantor, but you're not the trustee and you're not the beneficiary. That is really the type of trust that's often used for individuals with very high net worth that are trying to avoid estate taxes. Estate taxes on the federal level, we're talking about assets that are more than 13 million, give or take. And in New York State, there's an estate tax that is at roughly 7 million, just under 7 million. So if you hit those thresholds, then you're paying on the federal level 40% tax, and around that number. In New York State, you're paying 16% tax. So that's a lot of money to pay out. You could be paying 56% if you live in New York and have an estate that's worth, let's say, 35 million. You're paying a lot. So that's why you would set up one of these IRS type tax asset protection trusts to avoid that. But for most people, we're looking at the first two boxes. We're looking at either the revocable or the irrevocable closed box and using that to get some benefits from it. And the benefits, I already mentioned the asset protection. With asset protection, if you're in that, you have your assets in that closed box, then your creditors can't get at you with those assets. They can only attach the assets that are in your name. The assets you put in the trust are going to be in the name of the trust. So you're getting protection there. And then instructions. You get to design this trust. So you put in all of your instructions. And you can have all kinds of conditions in there. You can account for all kinds of different scenarios that might crop up. So for instance, let's say you're concerned about remarriage, right? If you are married and you die and your spouse gets remarried, maybe you have children. Are you certain that the house that you have or whatever assets you have are going to be passed down to your children? Or might that spouse, that widow or widower, end up giving that stuff to their new spouse or children with their new spouse? If you want to make sure that your children are going to be protected and inherit, you want to use the trust as a vehicle to do that, to ensure that it does happen. Also, a great use of the asset protection trust is for Medicaid purposes. If you want to be able to qualify for Medicaid, one of the main strategies that we use is to transfer your assets into an asset protection trust. And if it's there for 5 years, then it will be completely protected from Medicaid. Now, again, I'm talking about New York law. It's similar in other states, but there are some differences. Some states don't have that 5-year look back period. So that's why I say the 5 years. There's a 5-year look back period for Medicaid. But if you have your assets in the trust, after 5 years, they're really not considered your assets. They are the trust assets. So there's also the option, there's other kinds of trust that we use with Medicaid planning, but that's a whole nother discussion. It would take too long to go into right now with the short time that we have. But when we talk about control, another benefit of the trust is control, because you're controlling where your assets are going during your lifetime and after you leave. You can set up your trust so that the assets you give to a loved one, or excuse me, the assets you leave to a loved one in that trust, you leave it in a trust that it can have conditions on it or not. But rather than say, give it outright to your loved one, your child, your sibling, you put it in trust for them, because then they get the benefit of it being in an asset protection trust as well. And some of the other side benefits of that is anything that's left to them through that trust, it safeguards against a future divorce that they may have. It also safeguards against someone who may be on some like disability benefits, government benefits for disability. If you were to just leave them in inheritance, and I've had this happen to some clients and we had to deal with that. If you were to just leave them in inheritance and they're receiving disability benefits, it'll knock them off their benefit, and they would have to first spend down what they received and then apply again. So rather than do that, you use the trust vehicle, and in that case, it's a special needs trust, to make sure that they can receive those funds that are in trust and use that for their benefit, but also still keep the benefits, the government benefits that they're receiving. So there are all kinds of advantages of using a trust in many ways. Then there's the certainty. Again, like I said, you're not in the land of probate. The trustee, if you pass on, then the trustee picks up the reins and they say, okay, let me read the instructions, and they can distribute the assets to your beneficiaries as you intended, and it can happen right away, or at least in accordance with your instructions and as to how you want it to happen. It's also private, right? It doesn't get filed anywhere. There's no government vault where, or at the courthouse or anything like that, where someone can come and review this trust document that you've created. It avoids probate. And it's more cost efficient, because while a trust may cost a little more to draft than it does to draft a will, there are no additional expenses on the back end when you're dealing with the trust. You're not paying a percentage of the value of the estate or anything like that. So it can be worth it to pay a little bit more upfront to get that trust created rather than go through probate. It's almost always worth it. All right, so that was why you don't give anything to anyone you love. You put it in a trust. Now, I also say don't own anything, right? Don't own anything. Make your kids some trust fund babies, right? And create that trust. And you can be a beneficiary if you have like I said, the revocable open box trust, and you can be a beneficiary, but your trust owns the assets. But even more, for more asset protection, for greater coverage, do the irrevocable trust, and you get all the benefits I already outlined. You don't own it, the trust owns it, but you get to benefit from it. And it works out to have those advantages a little more. So you really are protecting the wealth that you're building. You can't have generational wealth if it's not being passed down to the next generation. So you want to make sure you're protecting all of that wealth so that you can pass it down and have that. So let's talk about homes, because this becomes a huge mistake that a lot of people make, right? Where they put their kid's name on the deed. Don't do that. Don't put your kid's name on the deed to your home. You want to instead safeguard your home in a trust. That's going to it's going to protect your home from Medicaid, right? As I mentioned earlier, as long as it's there for at least 5 years. It's going to give you some creditor protection, because if you're sued, right? And lawsuits happen all the time. You could be in a car accident, anything could happen. But if you're sued, the home is not in your name, it's in the name of the trust. And so it is not at risk of being subject to a judgment that might be issued against you, right? You also wanted to minimize taxes with the putting the home in the trust. And how do you do this? In this case, I'm really talking about what happens when the home is transferred down to, let's say, a child, and the child decides to sell the home. If you had it in trust, then they take the value of the home at the date of your death, which means they're not going to have to pay any capital gains taxes. But had you put your kid's name on that deed, let's say 10 years ago, and then you passed away, and now the child is trying to sell the home, their cost basis is going to be the value of that home back 10 years ago when you put their name on the deed. And so when they go to sell it, all that gain that has occurred in the past 10 years is going to be counted, well, not counted against them, but it's going to be looked at, and they're going to have to pay capital gains tax on that 10 years of gain. Whereas if you had not put them on the deed, it passed to them at death, there would be no capital gains tax, because they get what's called a step up in basis. So that's another key thing. You also want to be able to keep control. It's your house. If you put it in the trust, you maintain a life estate for yourself. So you still get to live there for as long as you live. But you are still in control. If your kid's name is on the deed with you, then that property is subject to not only your creditors, but your kids' creditors as well. If they get into some trouble or something happens, then creditors can they'll look at that property as them owning a share of it, and it could be at risk to liens that are related to your kid having, since they're now one of the names on the title to that deed. So they could also sell their share of the property, right, without even your consent. So you're really giving up some of that control if you go and do that. The better thing is to put it into a trust. You keep that life estate for yourself. You let the kids know that they'll be entitled to it upon your passing. They get that step up in basis, so they don't pay capital gains tax. It's still being protected from Medicaid if it's been there for 5 years, so you're not losing the home because you're having to pay for Medicaid expenses if you end up going into a nursing home in your later years because you need that care. So there are a lot of advantages there to making sure your home is safeguarded by using the trust. So, Stephanie Mills liked to sing about home. So we want to make sure home, which is usually our most valuable asset, is well protected. And, that's about all we have time for this session. So I want to say, come on, ladies, let's get information and make sure that you have an estate plan in place for you. If you are in New York and would like to speak more with me, I'm happy to do so. I ask that you would please complete the evaluation form. And if you sat through this, we give complimentary we call it a vision meeting, complimentary consultation if you sat through one of our workshops. Now, this is an abbreviated one, but we'll still give you that courtesy. But you do have to complete the evaluation so that I know that you were here. And if you do that, you can also go right ahead and schedule that vision meeting with us. And you will have it be discounted. It's a $500 discount because that's the cost of the vision meeting. But that would be waived because you were here today. And so with that, is if there are any questions, I would be happy to entertain those. Or you can always reach out to me. My contact information is there, and I'd be happy to chat with you a little bit. I do see a question in the chat. Can you talk about ramifications when it comes to beneficiaries if they are designated on your accounts? They still go through probate. That is an excellent question. With our short time, I didn't spend any time on that. So thank you for that. So one of the things that people often ask about is, well, I have a bank account and I have a beneficiary designated on my bank account. That's great. That's fine. So what's going to happen with that is the person that is the beneficiary on that bank account would go to the bank, show them the death certificate, and then they would be able to receive those funds that are in that account. It does not have to go through probate, and it is pretty immediate. So that's another way, quick way to distribute an asset to another person. So that's certainly fine to do. There are a number of different assets where you can put a beneficiary designation, like bank accounts, even your retirement accounts. But if you want to put some more instruction around it or guidelines around it, then it's important, or it's a good idea, I should say, to consider the trust. Because what if your beneficiary is a minor? You want to be able to give that instruction as to who's going to be in control of that money for that minor, right? And then you can put in instruction about, maybe you want them to get a distribution of a certain amount per month. Maybe you want to have it suspended if they're not achieving in school at the level that they should be. Or maybe you want to give guidelines that say, I want to encourage them to buy a home or start a business. And so there'll be a little bit more leeway or flexibility for that. Maybe they get a little more that way. So it's just so many different opportunities to give more direction if you do it within a trust, as opposed to a direct beneficiary designation. But, if without it, it's at least, better than not having anything at all, because you don't want a situation where you pass or someone passes and there's no one named on anything, because then now it goes to the statutory rule of succession. And there may be people in your family that are receiving these funds that you really didn't want to get any of your assets. So because you completely lose control over that. So it's always better to have some instruction as to no instruction. Like I said, be like Janet, be in control and make sure you have everything listed the way you want it to be. And let me see if there's another question here. I see, does one have to live in the state of New York to work with you? Yes, you do. I am a licensed attorney in New York State only. And so I am not licensed to work with people outside of New York State. However, I am part of a group called Lawyers with Purpose, and there are a number of us around the nation. And so I could possibly refer you to someone that might be in your area if that's something of interest to you. So you can shoot me an email, or you can put something in the chat or what have you, and I can try to help you out to identify someone to help you with that. All right. Let's see. I don't see any other questions in the chat. So I am just going to say, please, I hope that you have taken advantage of the various speakers that were here today. And I want to thank Myrna for inviting me to participate in this Wealth and Wellness Summit for Women, and making sure that you're empowered. One of the our acronyms for my practice, and actually I didn't even mention, I'm in practice with my husband actually, so it's that's the Robert Hoskins that you see on the screen. And our sort of tagline, if you will, for our practice is peace for the family. And peace is an acronym that we use to stand for P, protection, E, education, because we do a lot of these community workshops, A is assistance and giving you assistance to make sure you are able to accomplish your goals and meet them. C for care, and that references our long-term care planning. And then E is empowerment, because we want to make sure we're educating you and giving you tools to empower you to get what you want accomplished, and to make sure that you are maximizing all the efforts that you put into building your fortune and building your family wealth, and making sure that it goes to who you want it to go to, protected, and in a way that minimizes the headache, the fighting, the taxes, all of that. So that's what I have for you. I thank you, and I wish you a wonderful rest of the day, and enjoy the rest of the speakers on this program.